Very excited to talk to you about this topic today because it's very timely in that so many people ask about this. Like they've heard about the 5-year look back, but they don't quite exactly know what it means, and they don't necessarily know what they need to do to be prepared for it. We have people who come in all the time with myths, with misinformation, with information that may have worked for somebody else, but they didn't think about it fitting in their situation or hadn't thought about other alternatives that they have. So, what our goal today is to do is to talk about the 5-year look back period and what you can do to prepare for it. So, just before we dive into everything, just a little disclaimer: my insurance company makes us say this, right? What we're going to talk today about is legal information, right? Nothing on this broadcast today is going to be specific legal advice. So, what all that means is, right, is just don't run out and start doing this stuff. If you are interested in doing this, reach out to an attorney. We'll talk about some options that we have available to help. But there's no attorney-client relationship from today's webinar. I'm just happy to get out and have a number of interested people today on a lovely end of summer day here to talk about this topic. So this is going to be for you if you are frustrated about not knowing your options. Because maybe you've heard about the 5-year look back period. Maybe you don't quite know what it means. Maybe you had someone in your family where you lost a house to the nursing home, or the state took it through a lien after the person passed away. We are going to go through the different options that you have. This is also for you if you are worried about long-term care costs. What we're going to be talking about today, this whole 5-year look back, is about long-term care costs. Specifically, it's talking about nursing home care. There's also home care, and that's a different program and a different look back period, different than the 5-year look back period. Anywhere I can try to mention how this would also apply to community Medicaid as we go through this webinar today, I will try. I don't want to make it overly confusing by jumping back and forth between the two programs. But most of what we're going to talk about today will work for either the home care shorter look back period of 2 years, 2.5 years, actually, I'm sorry, and the 5-year look back period for nursing home care. And this is especially for you if you want to protect your home and maybe even more for your family. Look, you have worked hard for these assets. You have saved, you have invested, you have purchased real estate, you've raised a family. This is the legacy that you can leave behind to them. This is how you can help set your family up in a better place than you were, just like you have taken all those steps raising kids yourselves all of these years with the effort and the goal to be to help the kids be better off. This goes for your children, this goes for your grandchildren. And in that same line, this is also going to be for you if you don't want to leave a mess behind. If we want to be cognizant of how we structure our estate plan to make it as easy as possible for our children to get access to the money that we've left behind for them without the need for a court involvement in this. We want to keep the state out of this altogether. So just imagine that you could wave a magic wand and that your hard-earned asset, sometimes the house is our largest asset, that is protected from long-term care costs. We can continue to know that our significant other, our spouse, can live in the house and we're not going to be forced to sell it. We also know that if both need care or there is no spouse living in the house, that the house can be protected. The equity that you have from blood, sweat, and tears put into that house can be preserved from the nursing home and allow you to leave that legacy behind that you want. And as it goes with all estate plans, when you take control over these decisions, you get to choose who gets what on what terms and when, instead of leaving those important family decisions up to the state to make those decisions for you. Now, the thing is, and why I'm so happy that everybody is here today, is because you need to plan in advance for the long-term care costs, specifically for the nursing home, right? We need to plan 5 years early. We need to do that before we need the care. When we're dealing with estate plans, by the time you need your estate plan, whether it be some of the options we'll talk about today, or even a simple will, right? By the time you need it, it's already too late. You need to plan in advance. Here's an example of a couple, changed the names, but this is a real life example of a clients that we had, that Hannah and Jake were married, right? And they transferred their home to a trust to protect it from Medicaid in 2020. But 5 months later, Jake needed nursing home care. Now, that meant that we did not get past the 5 year clock. Now, lucky for Hannah and Jake, because they were married, because Jake had a healthy spouse, we were able to undo what we had done with a properly prepared trust and put the house back in Hannah's name. We had to do that because Medicaid would have disqualified Jake for giving the house away during the 5 year look back period. And we were able to qualify Jake for Medicaid. And we did what's called second stage planning. Once we got Jake on Medicaid, then we were able to put the house back in trust for Hannah. And all of this was done without any risk of them being stuck, with negative tax consequences. And the thing is, for this client, though, we had lost the benefit of that 5 months, and we had to take a step back in order to take a step forward. Had Hannah and Jake done this in 2015, for example, then the house would have been protected if he had this stroke in 2021 or 2020. We wouldn't have had to go through with this. We would have been able to leave everything exactly as it was. And then the house would have been protected for both Jake and Hannah. See, the situation that we're in right now is that now Hannah, who is a similar age as Jake, is needing to get past her own 5 year look back period now. So had they done this earlier, they would have been able to start the clock earlier. So what we're going to discover in today's webinar is what exactly is the look back period. And we'll talk about how it works, because there's a lot, it's very confusing. Mainly in the fact that we talk about this look back period of 5 years, but you've all heard of, I know it, of the 5 year clock. And is that any different than the look back period? And how is one a clock and one's a look back period? And we'll take a look at that. We'll also then talk about common gifting mistakes. And you said, what are you talking about gifting? Whenever we're doing Medicaid planning, like we're talking about here, we want to protect assets from the nursing home, from home care. We need to get the asset out of your name. It can't stay in your name, because if it stays in your name, the clock never gets started. So we'll talk about different ways to make gifts. Some of you are going to be like, what? I would never do that. And some you might say, well, okay, that's a pretty good option to protect my access to the asset, my right to live in my property, my right to have the money if I want to sell it, but also getting it out of my name for Medicaid purposes. And what we're going to talk about today is specifically the home. Although you can protect lots of assets, we're going to focus today's talk on how to protect your home. And by the end of today's webinar, you'll see that trusts aren't just for the Rockefellers. This is how people preserve the wealth that they've accumulated, whether it be their home, their stock, their bonds. They use the trust to be able to protect assets. The Rockefellers are just protecting assets from different issues. They're protecting it from estate taxes. And what we're talking about today is protecting it from long-term care costs. They pay for their long-term care costs from investments, but they get hit with a 50% tax at the time of their death. Here, we use the trust to be able to protect our assets from the nursing home, which can run upwards of $600,000 to $900,000 for a married couple. And so that is an enormous expense that we need to plan ahead for. Now, before we dive into that, let me just tell you a little bit about myself and why I do what we do. Sheryll Law PC is in the business of helping people preserve a legacy for their family on your own terms, maximize the assets that you have protected and you have built to give to your children, keeping the state out of all of these important decisions and making sure that you set your family up to be better off than you were when you were younger. And they can now have time for education, and they can have money for and for a oh, I have a great example. We have someone who just told me this story. One of our clients, that the child inherited money, about $300,000, and during the pandemic, this child, who was 50 years old, right? They they had a child, right? The child needed an ability to work out for Olympic trials, but this was during the pandemic and the gym was closed. With that money, they were able to build a home training facility, and it wasn't even an enormous amount of money. I think we're talking about $100,000 there. And they were able to build a training facility for her to compete, and then she qualified for the Olympics. And this was something that was so important to that family, that was made possible by focusing on not wasting assets when we have other options. And that is what I do every single day and what gets me up and going. I wasn't always like that. This is me and my wife when we were young, and she's really the one who propels me forward. Besides that, she, her and the kids, and I'll show you them in a little bit. But I didn't always want to be a lawyer. I just liked helping people. And I first got a job when I was about 19, 20 years old in Southfield town as a traffic control officer. I had at the time wanted to be a police officer, and that's where I kind of got my first feet wet in the law. Prior to this, I had been going to school and I didn't know what I wanted to study, and it all just was really, really boring. I hated school at college at that age, but I took a law class when I was studying it for this job, and that was the first time that I ever really spent a ton of time looking into something and studying and preparing and analyzing and thinking, and the time just flew by, like hours went by. And so I just followed that trail, and I married my wife. That was us on our wedding day. And we had our first child, that's Eliana, about 2 years after that. And that really changed my perspective on life. And I saw in this child the future. And I had done some estate planning before that, but mainly just simple things, right? You do a will here, you do a power of attorney here. And that was no longer enough. I wanted to help families, specifically families, protect their assets so they can preserve and protect and impact with their own legacy the future of their family, as our parents, our grandparents, our great grandparents did before us. And I did that for another law firm. But after my daughter, this is my second daughter, was born, she was born premature. And I had been frustrated at the time. She was born, this is her at 31 weeks. And it was she was so fragile. But I was so frustrated at work at the time because I wasn't quite getting that vision across to who I was working with. So after Lily, this is Lily here, got out of the hospital, I left that practice and I founded this practice, Sheryll Law PC, with that vision in mind. And everything we do is with that goal in mind. And that's us there in October at a wedding. It's my brother's wedding. That's Eliana and Lily there in the front, and Brigitte there as well. Now, enough about that. Listen, you're here to learn about the Medicaid planning and the 5-year look back period, and we are going to dive into it. We're going to talk about how to make sure that you can get the care you need and protect your assets. Now, I told you I'm so passionate about this because the law is so complicated and there are so many pieces of misinformation out there. But the foremost thing that I love the most is watching a family's worry turn to relief, because we're dealing with heavy stuff here, and they're worried. They're worried about what's going to happen. They're worried about the assets. They're worried about their kids. They're worried about the kids' future. They're worried about the cost of long-term care. They're worried about everything getting exhausted and taken by the nursing home. And we know that there are options for them. And the fact that they didn't know that they had the option really puts them at a disadvantage. And when they learn that they have options and we can actually implement those options, that we see that relief and we see that peace of mind. And that's what we're going to cover today. The key parts of long-term care planning. We're going to talk about the Medicaid application and how you can get ready for it and how to avoid common mistakes. And we'll talk about protecting your assets from estate recovery. Now, first, the look back period. Is that any different than the 5-year clock? And the answer is no, it's not. It's just silly. It's the way we think about it is that Medicaid actually has a 5-year look back period. What it means is that if I applied for nursing home today, Medicaid is going to look back at all of my assets, my bank statements, my real estate holdings, my stocks, my bonds, my life insurance, my savings bonds, my CDs. They're going to look at everything for the period of 5 years. And what they're going to be looking for is for transfers of your money within that look back period. And they are going to take the assumption every single time that you transferred that money for the purposes of qualifying for Medicaid. You transferred that money to shelter the assets from Medicaid. They'll always take that position. Now, you can always try to overcome that because we get a lot of questions about, well, I gave $1,000 to the grandkids every year for Christmas. That adds up to $10,000. What do I do? We can overcome these things, but they're always going to jump to that. They're always going to jump to the fact that you did this to qualify for Medicaid. What happens is if you've made a gift during the look back period, let's say Medicaid counts it as a gift to qualify for Medicaid, then what they do is they penalize you. They will not allow you to get coverage until the penalty period has run. I mean, just to keep things really simple right now, but the way they do it is they say, look, you gave away $100,000 and there is a $10,000 per month penalty. So we just take $100,000, divide that by that figure, the 10,000, and we come up with a 10-month penalty period. That means for the nursing home care, the person who made the gift and who's applying for Medicaid will not be able to get Medicaid for 10 months. Now, the question is, who is going to pay for the nursing home during that time period? Well, if the person has other assets, then they will have to pay for them. And if they don't, well, then we're in a problem. We're in a really big problem because they don't have assets to pay for the nursing home care because they gifted them all away. And Medicaid is saying, nope, sorry, we will not cover you. And so they're really stuck. So whenever we're doing any of our planning, and we'll talk about some of the gifting ideas, we want to keep that in mind. We don't want to leave anything up to chance. Nothing. We want to take care of everything. We want to think of every possibility and maintain control. So we'll talk about that. Now, how do we get to a 5-year clock? Well, this is done so like this. If it's like just switching the whole thing around, because we're not applying for Medicaid today. I already told you we're planning in advance. We need to do this before we need the care. So if I applied today, there'd be a 5-year look back. But if I sat here today and said, let's gift out the home, we'll talk about the different strategies on how to do it. But let's say we're just going to do it. We're going to gift it out. Well, that means that if I gift it out today, we can start a 5-year clock, meaning that in 5 years from today, if I apply for Medicaid, the transfer, the gift of that house will not fall within the 5-year look back period. So today is September 14th, right? 2022. 5 years from now, September 15th, right? We're going to go one more day. September 15th, 2027, we apply for Medicaid. Today, we transferred the house. 5 years back from September 15th to 2027 would be tomorrow. And the gift of the house today would no longer be in the look back period. So that's why we call it a clock, because it's easier for us to conceptualize and communicate it as a clock because we're looking forward. We're not really looking back. Medicaid looks back, but we all look forward, right? So we're thinking of a clock on each gift that we make. 5 years till we can get Medicaid eligibility. 5 years. If we need care during that time period, we're going to have a penalty period assessed. Okay. This is all designed to make people plan ahead, but also recoup, and restrict who can get Medicaid. People who make gifts 5 years before can get the Medicaid program covered. People who don't can't. Okay. Or we have to look at other avenues. It's an arbitrary number. I mean, it's the legislature, the congressmen, the senators, right? They've passed this law. They can change it. It used to be no look back period. Then it was 2.5 year look back period. Now it's 5 year look back period. There's been talk of 10-year look back period. This is just an arbitrary number. But like on your taxes, right? Every year you file, you have the opportunity to take a standard deduction, sometimes two if you're married, right? Basically, you get to write off a standard deduction of income. Yeah, you would never at tax time go, yeah, that's cool, but I think the government could use a little bit more money, so I'm not going to take that this year. Let me give a little extra money to the government. No, you have the option to do this. You exercise those options by being proactive, being on the call today. You're going to learn how you can do that, and it's really, really, really simple. Now, on Community Medicaid, I told you I'll jump back and forth a little bit. I don't want to make it too confusing, but Community Medicaid. Now, what that is coverage of home care, right? The 5 year look back period is for nursing home care. Nursing home care is in a facility, right? A long-term rehabilitation facility. Maybe some of you on the call have had a parent, or you yourself have been in short-term rehabilitation, maybe after a fall from a hospital. This is usually the same facilities. It's just a difference between a classification of how long the person's going to stay there, whether there is a discharge plan in place. But for Community Medicaid, this is where someone can receive coverage, like paid coverage of aides in their house, okay, to help, though, with activities of daily living. This is stuff like getting around the house, toileting, right, going to the bathroom, getting dressed, bathing, cooking, cleaning, getting up, getting down, right? All of those things to help a person stay safe and be able to live in their home. There was a goal to not have people institutionalized, right, in a nursing home, although they do have a correct fit for the right circumstances. And we always sit with lots of clients, and they always go, if I do this planning we're talking about, does that mean I have to go to the nursing home? No. Look, we're planning here. We're planning for the worst and hoping for the best. Like, nobody ever wants to go to a nursing home. Everybody would love to stay home. And that's why it's important to plan ahead for this as well, because if you can stay home safely, you decrease your chances of the likelihood of needing a nursing home. Because what we find is most people need a nursing home after a fall at home. So that's most people will have deteriorating health. They become unsteady on their feet. They fall at home. There's a break of a bone, usually a hip, sometimes leg, sometimes arm. And then that's when they need a nursing home, because now things have just escalated from that point. So Community Medicaid can be really important. Now, there is currently a little weirdness going on with this. I mean, I have no better word for it, right? In October 2020, New York State passed a law, right? They passed a law to create a 2.5 year look back period for Community Medicaid. But what was happening in 2020? We were smack dab in the first year of the pandemic. And that pandemic has continued now, and the federal government continues to extend the public health emergency every 90 days at this point. And every time they do that, they prohibit the state of New York from implementing this new look back period. So we're in this weird, right? I told you it'd be a weird situation where we have a law that says there's a 2.5 year look back period, but the state is prohibited from actually applying it. So when we're putting in applications for our clients for home care coverage right now, they're not getting a 2.5 year look back period. So even if they gifted assets out yesterday after the effective date of this new law, they're not getting penalized for it. What happens with that in the future? I don't know. But our best guess is that hopefully the people who are already on Medicaid, when they can finally implement this law, they're looking at maybe the first quarter of 2023. Those people that applied before the implementation of the law, they'll be grandfathered in. I don't know about you. I could never guarantee that to anybody, but I could tell you, if you're on the fence of needing coverage now versus potentially later, now would be the time to apply, because at least you set yourself up for the possibility that you could be grandfathered in. If you don't do anything, then nothing changes. The law goes into effect, and then there's no way you're going to get grandfathered in at that point. But if you made gifts prior to that and applied for Medicaid prior to that, I just don't think the state has the resources to be able to go after all of those people and then continue to process all the new applications they get day in and day out and month in and month out. So at least you set yourself up for the possibility that you could get grandfathered in. If you don't apply, there's really no chance you get grandfathered in at all. So don't miss the boat on that if you are on the fence about that. So some common mistakes and misconceptions we hear, and people come in with them, and that sometimes they're hard to clean up. The first one is annual gifts. All the time we hear, well, I can give away $15,000 a year to an individual, right? The answer to that is yes, but not for Medicaid purposes. It's for gift tax purposes. So that number is a real number, although this year it is 16,000. It is a real number. It means that you can give money to someone gift tax free, as long as the gift to them was under $16,000 per year. So, for example, if I wanted to give my two children $16,000 each, I could give them $16,000 each, and none of it would be subject to a gift tax. But if I was applying for Medicaid, those same gift tax-free gifts would be a big problem. They would be a big problem for Medicaid. They would penalize me for those gifts, every single dollar of them. So $32,000. They would penalize me, meaning that I would not be able to get nursing home care for a period of time because I made those gifts. Another problem is that we see is that we don't document what's happened as things occur, because when you apply for nursing home care or home care in the future, and when we need to do coverage application, you have to show everything. You have to show all the statements. You have to show all of the transactions. You have to show all the check images. You have to show all the deposits. And if there's money going back and forth, and there's money going from mother to daughter because daughter paid for something on behalf of mom, and we don't document this all, Medicaid will always, time and time again, jump to penalize the applicant. They'll penalize mom because they'll say that you transferred that money for the purposes of qualifying for Medicaid. We had a case one time where mom was in a nursing home because she had fallen, and she was in the short-term classification part of it, and she wanted to come home, but she didn't own a home. So she took $20,000 of hers and retrofitted a mother-daughter apartment in her son's house. So her son owned the house and had this unfinished room down there. And they put a door in, put steps in, created a living space for mom in that in the basement of the house so that she could return home. And she did. And then that worked for 3 years. But then in year 4, she had to go back to the nursing home and apply now long-term for nursing home care. And when she did that, Medicaid took the position that you invested $20,000 in your son's home. You gifted him $20,000. They didn't document exactly what was done. They didn't document the need for it. They didn't have a physician's note about why it was necessary for discharge, for safety. They didn't have receipts. They didn't have the vendor issue, a receipt or an invoice showing what the work was done. And without that documentation, we were unable to overcome that presumption, right? The department's position. Not could we have taken it further through an appeal, perhaps, but it just didn't make sense given the cost of an appeal versus the $20,000 penalty that we're talking about. But at the original level of dealing with the county and the first level of appeals, we didn't really have document to back it up besides our client's word, and that wasn't enough. And gifting property, again, is the same issue we see where you make gifts for Christmas, you make gifts for a scholarship, you make gifts to buy someone a car. You've got to document those at the time of what those were and what the intent was if they were made, so we can preserve that in the record. So when and if you need to apply for Medicaid, that you do have that protection. The other common mistake we see is procrastinating on planning for long-term care. Like, I get it. Number one, this is difficult. Number two, this is heavy stuff. Number three, who the hell likes to think about this? I mean, this is really, really difficult. You're talking about your own or your parents' incapacity, illness, death, sickness, nursing homes, right? But the thing is, if it's going to be needed, if it's going to happen, it's going to happen anyway. It's going to happen anyway. And so we could either be prepared for it or we can't, or we can be unprepared for it. But at the end of the day, truth, right over here, truth is objective reality. Whether you like it, whether you don't like it, it doesn't matter. Whether you think about it, whether you don't think about it, it doesn't matter. It exists, right? And so that is reality. And so to acknowledge that and plan ahead for it is important. Like Hannah and Jake that we talked about before, they are in a situation where now we hope that Hannah can get past that 5-year look back period for herself. And if she can't, then they're going to wish they had planned earlier. Now, they're not out of options, but the original plan that we put together for them would save 100% of their assets. But if they don't get past that 5-year look back period now for Hannah and she needs care, we're probably looking at saving about half, which, again, they'd be very happy to save half, but they could have saved more if they had planned earlier. So don't wait if you're considering this. The last piece that we see as a big mistake is people do not plan for Medicaid recovery. And what this is there's a little difference between actually qualifying for Medicaid and then the state having a right to recover. We kind of like all throw it in there when people call our office and they go, yeah, what do you want to do? Oh, I saw the nursing home take mom's house and I want to protect it. Well, it's a little more nuanced than that. And I don't want to get into all the specifics to confuse anybody on this call. But I want to just give you an analogy so you can explain. A state and Medicaid eligibility is like going out to the bar. And if you go to the bar and you order a drink, the bartender's going to come with the drink and he's going to ask you, do you want to start a tab? Oh, okay, yeah, I want to start a tab. Great. Can I have a credit card? You give him a credit card. Great. So now you've just qualified to get drinks at the bar tonight, right? So now you order a couple cocktails. You order another one, a friend pops over. You gotta get a drink, right? Wonderful. Maybe get a little food too, why not? And then at the end of the night, though, the tab needs to be settled up. You tell the bartender you're going to close the tab. Bartender comes over with an accounting of everything you ate and drank all night. And now you got to pay that bill. That's how Medicaid works, right? Medicaid eligibility is like, how do we get the state to start paying for the care that we need? Okay. And state recovery or Medicaid recovery is talking about how do we stop the state from coming back with the tab later on? So look, everybody's got Google and so much information at their fingertips. So we see this come through our office so much. Person says, why do I need to transfer my home? It's under the allowance, the cap of, it's right this year, it's about $890,000 in equity that's not counted for Medicaid purposes. They go, well, if it's below 800,000, right? 890, let's call 500,000. I don't got to do anything with it, right? I can get Medicaid. And they're right. They're right 100%. They can get Medicaid. They can get Medicaid eligibility. They can get the bartender to start food, serving drinks and paying and serving food. But what they're forgetting about, or they're not forgetting about, they don't know. What they don't know about is that if they leave that house, exactly where it is in husband and wife's name, for example. When they both die, the state will come back with a lien to record against the property to cover everything that was paid out. They will come like that bartender with that tab of all the food and drinks, all the hospital stays, all the nursing stays, all the aides that were paid, all the transportation, all the grab bars, all the durables, diapers, right? Clothes, all that stuff. They'll come back with a tab and it'll get paid from the house. So when you do that, all you're doing is punting the can down the road. You can get the care, but you're going to end up paying for it. And this also goes for all the other assets. If you anything in a person's estate, this means in their sole name with no beneficiaries, will be subject to estate recovery through the Medicaid liens. So anything that is in their estate, the state can come back after, even if they were eligible and getting coverage. So equally, if not as important as just the Medicaid eligibility planning, is planning for the Medicaid estate recovery to make sure that the bartender can come back with the tab, but there's nothing left on that credit card. There's nothing left. There's nothing in the estate to collect from. Okay? So let's talk about how do we actually get things out of our name. Okay? Well, I mean, it's simple. I mean, you could just get it out of your name. Okay? This idea of an outright transfer, let's talk about it in the context of the house. This can be done, and the reason why I say it's simple is because all you need to do is prepare a deed. You prepare a deed giving the house to whoever you want. But for today's call, we're going to talk about the children, right? Give the house to the children. Put their names on the deed and take your names off. Now, as long as it's done before the 5 years, so the 5-year clock has run or it's done before 5 years, then it won't cause a penalty. But if it is within the 5-year window, it will cause a penalty. But all the guests were. But the major downsides of this are you will lose the right to live in your house. Yes, let me just repeat that for you. You will lose the right to live in your own house. You could certainly be given the right by your children, whether they want to rent it back to you or not, or so graciously let you live there, right? But legally, you do not have the right to live in your house, which means that if something happens to your child and they get divorced, they are sued, they die, the house is not yours. It's going to be divided up in an estate proceeding according to their will. It's going to be foreclosed on to collect against that judgment. It's going to be divided up in a divorce proceeding. People do not like that. So while it is simple, it creates some really, really negative consequences. Another one is you lose your property tax benefits. You will lose them. So if you're getting an enhanced star exemption, you will lose that right. And that will increase your property taxes. It also has negative income tax consequences, meaning when your kids inherit the house and when they sell it, they will pay more in income taxes than if you had kept it in just your name. Okay. And also, it's completely irrevocable. The only way that you can get it back, the only way is with their permission. Now, you say, everybody says it right now, my kids would never say no. But sometimes there's a falling out. And everybody will tell me no. But statistically, we see it time and time again. It will happen to a family. I hate to see it, but it does. There'll be a falling out, and you're not going to be able to get the property back. But assuming that's not you, that's not your family, no way, never. Again, planning for the unexpected. If one of them predeceases, dies before you, if one of them gets sick, if one of them needs Medicaid, if they get foreclosed on, if they get a judgment against them, if they have bankruptcy, divorce, you're not going to be able to get it back. It's going to be stuck there. So if you are considering the simplicity of an outright transfer, just putting the kids on the deed, right? You got to think about the what ifs. I'm not here to tell you that the what ifs mean you have to do it that way. We're never here to do that. We just want people to make educated decisions, knowing all the options and knowing, like, logically what can they expect, not just go with something that they thought of. So you got to think about this. And if that is scary to you, it's scary to me, but if it's scary to you, then I would think that that's not the best option for you. The other thing is to think about is if you have other assets to protect that you can do more with, like, for example, the trust that we're going to talk about, and do more and have control about that. And really think about that irrevocability. The other piece of it, let's jump ahead 1 second, make sure I have the slide here. Real preview. Okay. So the other option in terms of simplicity is that we can do, instead of an outright transfer, you can do what's called a life estate deed. And so you might be sitting here going, oh yeah, but that's what mom did. So what are you talking about, this outright transfer thing? Well, I did a life estate deed for mom. What is that? Okay, so what a life estate deed is also a simple option. What it allows you to do is remove some of these negative tax consequences. It'll allow you to remove the issue of your right to reserve the property. You'll have a right to live in that property. Like, that's the biggest. That is the biggest benefit of this, is that you have a right to reside in your property. That's what's called a life estate. You reserve the right to live in the property. You give the future right to the children. Okay. Now, these two problems right here, the loss of your property tax benefits and the negative tax consequences, are gone also. So actually, by doing the life estate deed, you can knock out those three. Okay. You reserve the right to live in your property. You will not lose your property tax benefits, and you will not have negative income tax consequences, giving your kids a higher tax bill down the road. But why? That sounds so great, Jay, right? What about that? There's got to be a downside. The downside is it doesn't take care of this irrevocability. Things happen. Like Hannah and Jake, we talked about earlier. Hannah and Jake, we needed to get their house back. Hannah's son, after they had done that, had passed away. If we had done this, Hannah's son's children, her grandchildren, would end up owning the house, because his son had a will. So Hannah's son had a will, and Hannah's son's will said, to my two kids, equal shares, trust. Great, wonderful, simple plan. What would have happened there is that those children, who were 17 and 16, were not going to be able to give back the house. They're minors. They wouldn't even be able to participate in that. That would have been irrevocable. We really would have been up a creek without a paddle with that one. But because they had not done the life estate deed, they had another option, which is the Medicaid Asset Protection Trust. That's what we're going to talk about next. And there we'll talk about how that resolves this issue and gives you the benefit of being able to revoke what you've done if circumstances change and your goals change. Or if you just don't care and you want the money back and you want to go travel around the world, hey, it's yours, right? Do it. That is really, really, really important. Now, why did people do life estate deeds? People took that calculated risk. Because prior to 2006, so this was very popular prior to 2006, there was a different look back period for the trust transfers and for the life estate transfers. There was a 2.5-year look back period for the life estate transfers and a 5-year look back period for the trust transfers. So, because, like I said, your biggest issues is going to be procrastination, and overcoming that is that people wait. And so they would sit and go, oh, grandma or mom or myself, or I'm 85. If I do the life estate deed, I will only have a 2.5-year clock. So 2.5 years until I get protection. And if I do the trust transfer, I'll have a 5-year clock. And that's a lot longer. That's double the amount of time. So let's make an educated decision here, calculated risk about that, and do the life estate deed. But today, flash forward to today, after 2006, there's a 5-year look back period for life estate transfers and a 5-year look back period for trust transfers. So the two are the same now. It doesn't differentiate between, did you do a life estate deed or did you do a trust transfer? So now you're taking more risk doing a life estate deed because of this irrevocability than you are with the trust. Now, let's talk about that trust. We're going to talk about it as a Medicaid Asset Protection Trust. There's really no such thing, really, right? At the end of the day, it's just it's a contract, right? It's a written document with law, with terms, beneficiaries, provisions. We're going to call it that so we can conceptualize it, right? You might say, well, I thought this trust, I've heard about it, is it irrevocable, right? And the answer there is it is an irrevocable trust. And I remember when I said there's really not a Medicaid asset protection trust, there's really irrevocable trust and there's really revocable trust. This trust is not irrevocable, even though you might think it is. And this is another misconception. The reason is because an irrevocable trust is still revocable. You're like, wow, mind blown. I know. It's confusing, right? An irrevocable trust is still revocable. All that it means to be irrevocable is that you, the person that created the trust, can't revoke it on your own. You need the consent of the trustees and the beneficiaries. Okay, so two classes of people, the trustees and the beneficiaries. With their consent, you can revoke the trust. And you said, Jay, well, how is that any different than the life estate deed? The thing here is that you reserve the right in a properly prepared trust. By the way, they're not all the same because, again, like I said, it's not like something you just pull off the shelf. With this provision in there, you will reserve the right to change the trustees and change the beneficiaries at any time. That is an option that you do not have under the life estate deed. So if you want to revoke the trust that's irrevocable, but not really, you need the trustee and the beneficiary's consent, and then you can revoke it, and they can't agree or don't agree or won't agree, then you can change them. You're fired, right? You just get rid of the trustee by the stroke of a pen. You get rid of the beneficiaries by the stroke of a pen. You do not need their permission. You do not need their consent. Sayonara. See you later. I'm appointing my friend Jane, who's going to sign the dotted line for me to revoke this. And so this Medicaid Asset Protection Trust takes care of all of the downsides of the outright gift and the life estate deed. It'll protect the home from Medicaid recovery. It'll get the person eligible for Medicaid once the 5-year clock has run. The state won't be able to come back after the house after the person passes away. It'll protect the right to live in the house. It'll protect those income tax benefits that we talked about and not raising the income tax bill that your kids would have to pay and actually minimizing that tax bill. It'll preserve your property tax benefits. And it is the only option out of all of them, if properly prepared, is completely revocable. Okay? Everything else, you're stuck and you're leaving a lot up to chance. The other nice thing about the Medicaid Asset Protection Trust is that you can do this with other things. So we talked about the life estate deed, for example. That you can only do with a piece of real estate. You cannot do that with a stock account. You cannot do that with a CD, a bank account, a savings account, a money market account, a life insurance policy to protect the cash value. You can't do it. But with a Medicaid Asset Protection Trust, you can put all of those things in. Virtually the only thing that you cannot put into a Medicaid Asset Protection Trust is an IRA. But you're lucky because IRAs are treated very, very favorably by Medicaid. They're ignored as long as you set up the certain things that the state wants. You got to set up a distribution every month. And as long as you do that, the balance of the IRA is ignored for eligibility. And as long as you put a beneficiary on the IRA, it will escape the estate, meaning that they can't recover against it for the tab like we talked about. So absent the IRA, which is very favorable, anything can go into the stocks, bonds, vehicles, life insurance policy, pieces of real estate, investment real estate, personal property, if you have collectibles, stamps, coins, right? All this stuff can go into the Medicaid Asset Protection Trust. It'll protect it from the nursing home. It'll protect it from clawback from recovery, and it'll make sure that you pass the maximum amount of money to your beneficiaries on your terms, right? And create the legacy that you want. And I told you I'd talk about how it makes things cleaner and avoids a mess. When you do this, you avoid probate. Everybody wants to avoid probate, right? Want to avoid probate. I'm sure you've heard it. Avoid probate, because what probate is having to go through the court to allow your kids to get your assets after you die. Yeah, you put together this whole estate plan and the court needs to approve of it. And that's what happens when you do probate and you go through that process. you have to wait on the court to approve it. And everything needs to happen under the supervision of the court. But here, that would avoid that whole process. In today's time, it's cutting out like 7 to 10 months of having to deal with the estate just to get permission to have to deal with this, because we're waiting on the surrogates court over here. There's only one court in the whole county that deals with this, and they are backed up. And we're waiting and waiting and waiting. Meanwhile, we have mortgages that need to be paid on, pieces of real estate we need to secure. We got stocks that need to be sold. We have accounts that need to be claimed. There's no available cash to access until the court says so. And that's what we can avoid by having a Medicaid asset protection trust. All right, so pause. We covered a lot. What does this all mean for you? What do you need to do? You need to start planning more than 5 years in advance. Again, by the time you need this stuff, it's already too late. You need to have it in place ahead of time. You need to think about what's your tolerance for the risk that we talked about of making outright gifts versus life estate deeds versus transferring assets to a trust. What are you looking to do in terms of minimizing the income tax bill and your property tax bills, and thinking about things holistically? You also need to start to think about your trustees and your beneficiaries, because these are trusted people that are going to need to follow your wishes. So you're going to put together your best estate plan, and that's going to be driven by your goals, your wishes, your values. And you need to pick people that will continue those values, the people that will ensure that what you want will happen. This is really important in trustees, because people will always say, well, it's in writing, right? So don't they need to follow it? I mean, yes, it's a law. They have to follow the trust, but people break the law all the time, right? And then people sue, and we want to keep all that out of that. So you got to pinpoint people you trust. And I cannot stress this enough. If you are going to go down this route, you need to speak and seek help from a dedicated elder law attorney. This stuff is way too complicated, that touches way too many things. Like we talked about tax law today. We talked about social services law. We talked about guardianship court, and we talked about probate law. There's a lot going on here that someone who deals with all of this needs to be able to touch this, because anybody, I hope, I'm probably overstating, any attorney should be able to prepare a trust. Any attorney should be able to prepare a will. I mean, it was pretty much stuff we learned in law school, but we didn't learn how to do this. We didn't learn elder law. We didn't learn estate planning. The way that you get there is by working with a firm that devotes all of their practice towards that, and not what we call door law, which would be anything that comes in the door, right? If a matrimonial case comes in the morning and I do a divorce, and then I do a ticket in the afternoon for a red light camera, and then I do a will signing in the afternoon, you could do it all, but you can't do it with the depth that you have here. So you got to work with a firm like ours that works with just this: estate planning, elder law, trust and estates. Okay. So far you've discovered what the look back period is, how to avoid the penalty and those big mistakes, how to protect your assets, different options for outright transfers, life estate deeds, and Medicaid asset protection trusts. You learned about what those are and how you can best keep flexibility in your estate plan and protect your home while not putting it at risk to all the things that can happen. And if you get this one thing from this, I want everybody to know, this is what I want all of our clients to know, is that if you take action, right, you can protect your hard-earned money from the greedy hands of the government and make sure that your family is taken care of. Keep the government out of this and keep your money in your family where it belongs. Now, if you are interested in getting started, you're like, what do I do? I talked about a lot of information. What does a plan of action look like for me? And we have the option of a protect your legacy strategy session. Look at this. I mean, we would never start just going. And I started the whole webinar this way and told you, don't run out and start doing stuff. You got to come up with a strategy. But before you start up with a strategy, you need to know what your goals are, what your objectives are. And this session is geared to making sure that we can help flesh those out, talk about them together, get an idea of what those outcomes are you're looking for, what those goals, what those concerns are, what that legacy looks like for you, and then design a plan and a strategy around that. This is for you if you have a family. Look, we're talking about protecting a house for your family. You got to have loved ones you want to leave this to, because if you don't, then who cares? I mean, might as well use it all. Who cares if the government gets it if you don't love the people you want to leave it to? You also have to have worked hard for your money and have a desire to want to protect this for your family. Now, what we're going to do in this is a 20-minute virtual meeting. It is complimentary, where we will discuss your desired legacy, discuss your unique situation, provide you with additional resources, and discuss how we can help you with that strategy if you choose to hire us. It's a very important decision that you make, and it's an advisory relationship. You advise us on what your goals are. We advise you on opportunities to accomplish those goals. At the end of our time together, you'll have talked through the goals and wishes. We'll discuss exactly how we can help you and give you a basic strategy that will need to be implemented, but a strategy to get from where you are today to where you want to be. Now, don't forget, if you don't do anything, nothing changes. So schedule a meeting with us to discuss those recommendations. Now, after this meeting, if you decide to have us implement the plan that we have put together for you, we will go through this process. The first thing is, well, there's a lot more we need to answer beyond the initial idea of the plan, right? So we're going to design out those things. You would never start building a house without having the blueprints first. You wouldn't even put the shovel in the ground yet. We got to design it out. Look, none of this is customized. I mean, none of this is off the shelf. It's all customized exactly to what it is that you want and need. And then we'll sit and review it with you. The thing is, we will never send any of our clients a stack of documents and say to them, great, take a look at these and give me a call when you're ready to sign. The thing is, you don't know what they say, just like I don't know what my doctor's notes say when I go to get my blood work done. I need that professional, that advisor, to explain them to me and match my goals, dreams, wishes, visions, fears with what you have a solution for me. And show me how that works. That's what we'll accomplish in that second step. The third step is now we need to go ahead and sign everything. We break this apart because we want our clients to feel so calm, so relaxed, so much peace of mind in knowing that we're getting this in place at that signing. We don't want to rush it. We don't want to have heart palpitations. We don't want to have a knot in our stomach because you said something and we threw a bunch of stuff in front of you and asked you to sign it. So we avoid that. We're going to design it. We're going to review it. We're going to sign it. Now, the last step that we're going to help you with is funding. Now, this is so important. I can't tell you how many times we see this, and unfortunately, how much of an uncomfortable conversation it is, but also what a position the person is in when this happens. When you don't actually fund your trust, meaning you don't actually put assets inside of it, you don't ever actually get the 5-year clock running. So let's say we go and we do design and we review and we put together a trust and we sign it, and you never put your house into it by funding it, then you've never actually gotten the clock running. It's that action right there which really gets that running. So we include that in what we do because it's so important. We don't want to send you out in the street without that. So I want to open the floor to questions to anybody. I know we covered a lot today. I'm so excited everybody was here. Courtney, do we have questions that we can answer for some of our wonderful audience today?
Yeah, so there is a question in here. I might need a little bit more information, and it might require a further discussion, which we could always schedule a call. I'd be happy to discuss it. It says, what if the house is left in trust? It says something about, some relatives have their brother's house and they put it in trust for the mother. I'm not exactly sure what that refers to, but maybe it's...
What's the person's first name?
She actually just clarified. She means a life estate. So we touched on that a little bit.
So the life estate deed can work very nicely. The life estate deed can work nicely in the most perfect of circumstances, meaning that it never needs to be undone. You never want to change the beneficiaries. There's no circumstances that mean we have to get the house back. No one dies, no one gets sick, no one gets divorced, no one gets a judgment against them. It can work nicely in all of those things. Now, again, I'm not here to tell you that that's going to happen or not happen. I don't have that crystal ball. But as a matter of risk, that is what you're looking at. Getting it out of the name with a life estate deed can work, like I said, without any of those other things happening. If any one of those start to happen, though, you're going to wish you had the trust, because that allows you to change and adapt your estate plan to those changing circumstances. The other thing is the life estate deed can only take care of the house, right? And won't be able to take care of the stocks and bonds and life insurance policies and all the other things. Does that answer the question, or was there a part to that, more to that?
So there's just a clarifying statement. If it's done over 5 years ago, then does Medicaid not care about the life estate?
So, regardless of whether it's an outright transfer, a life estate transfer, or a trust transfer, it doesn't matter. If it was done 5 years before for Medicaid purposes, they don't care about all the stuff we talked about later on. We were just talking about the different options you have to get ahead of that 5-year look back period. So if you have mom, for example, that gifted the house out with a life estate deed already, and it was more than 5 years ago, that you probably should just leave the way it is, because if you bring it back and then want to do a trust, you're going to restart the clock. So you wouldn't want to do that unless you really, 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 really believed that you got another 5 years before a nursing home is needed.
Okay, perfect. And then there's another question. What happens to a 401k? I might just need some clarifying points. Do you mean when it's transferred into in regards to trust planning, or just protecting the 401k assets in general?
We're talking about like on the application for Medicaid, and when that comes to that time.
Yeah, I'm not sure. The question was just what happens to a 401k, if there's any
Well, if someone comes in, you'll let me know, Courtney. But what I think the question is saying is, what happens with a 401k if I need Medicaid, right? And so a 401k, like a IRA, cannot go into a trust. That's one of the assets that cannot go into a trust, which means you can't gift it out before the look back period, right? The only way to really technically gift an IRA or a 401k out before the look back period would be to liquidate the 401k or IRA and then pay all the income taxes on it. It'll be taxed as ordinary income that year received. So let's say you brought in $500,000 out of that IRA, you're going to be paying 37% taxes on that money. You pay the taxes. Now you have 2/3 of it left, and then you can go ahead and put that into a trust account and get the clock running. For that reason, though, that's why the Medicaid rules are so favorable to IRAs, and they also apply to 401ks. For Medicaid purposes, they don't differentiate between the two. They will make the applicant for Medicaid set up a distribution every single month. You don't need to do this now. You don't need to do that 5 years before the nursing home. You need to do it at the time you're applying for Medicaid, if that ever happens. You set up the distribution. What happens is Medicaid counts the distribution as income every month, and the balance of the IRA is ignored. So, for example, if I have a $400,000 401k and I take out $1,000 a month, the $1,000 a month is now treated as Medicaid income, right? And the $400,000 left in that account every month that goes forward is ignored for Medicaid eligibility purposes. Okay, so I got, each month that goes by, I got 490, I got 400, I got 399, 398, 397, right? That pot is ignored for Medicaid eligibility. For recovery, like the IRA, you just got to make sure that you have beneficiaries on it. And if you have beneficiaries on the account, it'll avoid the estate, because it won't fall to the will estate, right? And it will then avoid the estate recovery. So that's how 401ks are handled, just like IRAs.
Okay. One last question. 403Bs, are they treated the same as 401k
Same
in
thing.
terms of
Any
eligibility?
retirement account.
Any retirement, okay.
Any retirement account. Because the Medicaid rules recognize that they're not going to make you liquidate that account in order to put it into a trust to do the trust planning.
Okay,
Because you'd have to pay all that income tax.
Okay, I think that addresses all the questions in the chat. Again, if you have any questions at all, my link is to schedule. We can have a full discussion. So if there's any lingering questions, feel free to use the link.
Thank you, everybody, for coming today. And I just want to remind you, you've taken this action. Keep it going, right? If you don't do something, if this strikes a chord with you, you need to get this done before it's too late. Anything can happen, right? We all know someone where they retired and then they had a stroke the next week. We know someone who got into a car accident. We know someone who had a debilitating life change. You need to be prepared. I certainly hope that it doesn't happen to you. I hope it doesn't happen to me, but we got to be prepared. So act before it's too late. And you have options to protect your family, protect your money, and protect and preserve and leave a legacy that you want. Okay. I've left our contact information up here for you to go ahead and get in touch with Courtney to schedule those strategy sessions. Again, complimentary for the people who attended today's webinar. So if you have specific questions about your strategy, we can put that together for you and talk about next steps. Enjoy your afternoon, everybody.
Okay, perfect. Once again, the link is down there. And if you have any questions, the phone and email are there as well. And I'll happy to provide any resources and address your questions as needed. Have a great rest of your day, and I'll talk to you soon.